Now I'll call the first case on this morning's docket. That is case number 108351, Mark L. Hayes and Jennifer L. Hayes v. Neil Ruther, Consumer Law Association, New Leaf Debt, and EFA Processing Defendants.
May it please the court, Chris Joseph appearing on behalf of defendant Neil Ruther and also arguing on behalf of the other participating defendant, Consumer Law Associates, represented by Mr. Tom Gilman. At the outset, I would respectfully request 5 minutes of rebuttal.
5 minutes is granted.
This matter comes before the court in the form of a certified question from Judge Thomas Martin in the District of Kansas. Recognizing that the scope of the attorney exemption in the Kansas Credit Service Organization Act is unclear, Judge Martin has asked this court for statutory construction and, if necessary, for analysis of constitutional principles. The briefing in this case reveals that there are significant disputes about the facts, yet 3 of the 4 parties agree what the law really should be and what the law is under the exemption. There's limited dispute about the law. The factual disputes will be resolved at the trial court, and most importantly, the certified questions to this court assume all necessary facts. They assume the practice of law, and very specifically, the first question assumes an attorney licensed in Kansas to practice law, acting within the scope and course of that attorney's practice. It even assumes that that attorney himself or herself is exempt. The only question asked to this court is whether that attorney's law firm is then also exempt. The defendants, the plaintiffs, and the amici all agree that the answer is yes, that law firms are exempt when a licensed Kansas attorney acts within the scope and course of her practice and is responsible for the law firm's actions. So there really is not much disagreement about what the law is. Only the intervener, Attorney General, disagrees, asserting that no law firm can ever be exempt. A law firm must be exempt for the actions for which its attorneys are exempt. A contrary conclusion would lead to absurd results, as set out very fully in our briefing, and clearly a result that would be inconsistent with legislative intent. The absurdity, of course, would be that law firms themselves would be regulated and subject to penalties premised on the actual practice of law of their constituent attorneys.
If a paralegal is the one who performs the action that is in controversy, does the law firm get the exemption?
Well, I think the question or the test that we propose is whether or not it's within the scope and course of an attorney's practice of law, and whether or not that attorney is responsible for that. So it's the same test for law firms, for paralegals, and for the attorneys. Is it done within the course and scope of that attorney's practice? And certainly, attorneys can have paralegals assist them with their practice. And as long as their actions are within that course and scope, then the answer would be yes. The exemption extends to the law firm, extends to the paralegal. That's the only natural result from this exemption. If you strain the exemption, and if you truly limit it only to the licensed attorney and don't extend it to the law firms or to the assistants helping the law firms, you would have absurd results. You would have
how does the statute extend it? The clear, specific statute says any person licensed to practice law. How is a law firm, how is a paralegal licensed to practice law?
Well, it is true that this court only licenses individuals, that direct licenses are handed out to individuals. However, professional business entities, if organized correctly, for example, is organized as a professional corporation, statute authorizes such professional corporation to render the services of an attorney at law. So that's the first layer of analysis. But furthermore, the legislature chose a defined term that includes both business entities and individuals. And the legislature must have done that for a reason. And so on its face, it says persons. Now, there may be a conflict, as suggested by the Stork opinion, that you could read it another way, but when there is a defined term that includes both business entities and professionals, it is natural to conclude that the legislature and the statute extends the exemptions not only to individuals, but to business entities who are acting through licensed Kansas attorneys. Now, that seems to be the only fair way to read the statute. Now, I recognize that the Stork opinion provides an alternative analysis, which is what creates the ambiguity. There's clearly two possible ways to read the statute. I think the Stork opinion analysis leads to absurd results, is contrary to legislative intent, and should be rejected by this court. But because the legislature chose a defined term that includes business entities, it frankly makes a lot of sense that they would include, that they meant to include the exemption not only to individuals licensed, but entities rendering the services of an attorney at law acting through those licensed Kansas attorneys. Now, I think it's also significant to note that when 3 out of the 4 parties submitting briefing to this court agree that law firms can be exempt under the statute, but it is not clear that an entity can never be exempt. I think you have ambiguity just based on the briefing. There's 3 out of the 4 parties agreeing that law firms can be exempt.
Is this a democracy that majority rules on the rule of law?
No, Your Honor. No, Your Honor. But I do think it is quite significant that the parties are agreeing. Furthermore...
So can I clarify? So you're focusing on the word person in the statute, and you're saying the word person, even under the former statute, was defined to include the law firm at a minimum.
Correct.
Is that right? And so you're going to ignore then the remainder of that phrase, any person licensed to practice law in this state.
I'm not ignoring it. I'm pointing out there's a conflict. If that qualifier truly eviscerates the definition of the defined term, which says individuals and all business entities, that's confounding. If that's really what's meant, that's confounding, and thus you go to the next step. You say, okay, we have an issue.
Couldn't you also argue, I think as the state, as the intervener does, that it's not confounding? You can't read the word person to include associations or organizations and have it have any meaning with the phrase licensed to practice law. It's not confounding because it's nonsensical.
Well, if it's not confounding, that would mean that you conclude that the legislature erroneously or accidentally used a defined term instead of individual. If they meant individual, they would have said individual. Instead, they used a defined term that includes business entities. Now, I recognize that there's a conflict, but that's what leads to the next step, which is, do you interpret the statute in a way that would lead to absurd results? You look at legislative history, and that's where I think we clearly win, is if there is any ambiguity, if there is a conflict, and I think in this case there's a conflict on the face of the statute between a defined term, person, which includes business entities, and that qualifying phrase. That's ambiguity.
It seems that you are reading the statute to say a person practicing law within the scope of their license, which would incorporate probably KRPC 5.1, 5.2, 5.3, all of the provisions about an attorney supervising staff and all of those kinds of things that we recognize as necessary for the attorney to practice law. But isn't that something very different from the way the legislature worded it, which is not any person practicing law within the scope of their license, but any person licensed to practice law?
I recognize that there appears to be on its face a conflict between the defined term, which includes business entities, and that qualifying phrase. It is an awkward. I mean, it doesn't make sense, frankly, if you are, why use the word person, a defined term, and then immediately limit it to eviscerate the balance of the phrase? So that is confounding. It's also confounding when you look at the result, which would be to essentially nullify the exemption, because we all practice through business entities.
I guess the question is, how do we get there under the rules of statutory construction?
Okay. Well, at first you have a conflict. You have a plain conflict on the face of the statute between the use of the defined term, the intentional use of the defined term, and the statutory phrase, or the qualifying phrase thereafter. Furthermore, you have ambiguity that exists just from that conflict, and this court has found ambiguity in situations where they're less obvious and frankly analogous at points. Your Honor has found ambiguity in, or at least writing for the majority, in Miami County versus Kansas Rail Trails, where there was a gap in statutory framework. And I think this is more obvious than a gap in statutory framework. There's a direct conflict between a defined term and a qualifying phrase. In State X. Rail Morrison versus Oshman Sporting Goods, Your Honor, writing for the majority, found ambiguity in the terms weights and measures being used inconsistently throughout the statute. Again,
Move me to the next step. If I'm willing to accept there's an ambiguity, then what rule of
as soon as you have ambiguity, you move on to the rules of statutory construction, which include the absurd results analysis. If the results would be absurd and clearly inconsistent with what the legislature intended, that means it eviscerates entirely the attorney exemption, because attorneys practice through business entities. I'm here as an agent in my firm. Now, if I am immune or exempt, but my law firm is not, it's nonsensical, because my firm is the one that does the billing, my firm is the one that would be subject to penalties for my own actions. It's set out, all those exemptions are set out. My firm would have to obtain a bond, a surety bond, and provide client credit counseling. All those things were not intended to apply to lawyers or law firms. It would be an absurd result, and that is the doctrine that controls. Furthermore, you look at legislative intent, and I think it's clear from legislative intent. If you look at the second page of the minutes, the legislature, and it was on their own initiative, the committee put in there that, let me use the exact phrase, licensing or other regulations of law firms may be appropriate for law firms. However, it would be different from what was passed in the 2004 legislation. That's this act, the original exemption. So I think, if anything, that's pretty clear. It's a clarifying amendment. In that respect, I would agree with plaintiffs. All the rules of statutory construction, once applied, lead to the conclusion that clearly this was intended by the legislature not just to exempt individual lawyers, but it has to exempt their practice of law in a professional corporation, including paralegals, use of paralegals.
In my first question, I rewrote the statute. Is that what we have to do, or do we drop out the word licensed, or how do we get to the ultimate result? I mean, I understand where you want to end up from a policy application standpoint, but how do we do that with the wording of the statute?
You look at the fact that they use a defined term that includes business entities, and then you can conclude that business entities acting through licensed attorneys are part of the exemption. It fits, it makes sense. I mean, why else would they have used that term? That's the only thing that makes sense. That's the only thing that would not lead to absurd results. Licensed attorneys, Kansas licensed attorneys acting on behalf of law firms, me today, makes my firm exempt as well if I were triggering the Kansas Credit Service Organization provisions.
How far would that extend? If it's just a corporation that happens to have an attorney hired as an employee or even as a general counsel, but goes and provides all these other services through non-lawyers, is that good, or are you trying to restrict this to just professional corporations that could not be formed were it not being formed by licensed attorneys?
I think that the test is appropriate. The test that's appropriate for a lawyer would be the same test that would be appropriate for a law firm, whether or not the relevant actions were taken within the course and scope of an attorney's practice of law. So if it is an attorney, let's say it's Koch Industries that has a law group and is out asphalting streets, well, that wouldn't apply because the asphalting is not within the course and scope of the practice of law. But if Koch Industries was acting through legal counsel practicing law, then it would apply.
So would that mean that the exemption is dependent upon the facts of each case? Because you'd have to get behind whether the actions that are in controversy are part of the practice of law or something else.
Absolutely. It's the question of whether or not it was within the course and scope of the practice of law. And yes, it would be fact determinant, fact dependent.
So if we were to think that one of the purposes of this statute was to stop lawsuits in their tracks by exempting licensed attorneys, we wouldn't be able to use that intent because we have to get behind the facts in each case before we can apply the exemption?
Well, I think that the opposing parties have a point, and they find support in law for that, is that just because somebody's attorney doesn't mean they can operate in a function other than as a lawyer, not within their scope, and of course, the practice of law, and then claim the exemption. And that's a fair point to which we have to concede. And so it does, in my opinion, it does require analysis of the facts of whether or not they were practicing law in order to trigger the exemption. And I think that would be appropriate for law firms as well, or business entities associated with lawyers.
Before you sit down, I want to ask a question related to the second question. And my first hurdle that I have to overcome for myself is kind of a standing question. Why would we even entertain the question when none of the defendants and none of the parties are subject to the inherent license authority of the Kansas Judicial Branch or us?
Because they have Kansas licensed attorneys. And frankly,
No. Where's a Kansas licensed attorney a defendant in this case?
you don't have to. For example, let's take Stinson, Morrison, Hecker. If Stinson, Morrison, Hecker, which is primary based in Kansas City, Missouri, and probably organized somewhere other than Kansas is the defendant, but they have plenty of attorneys in Kansas, you can't just say they...
What attorneys do you have in Kansas?
We have 4 licensed attorneys in Kansas that we are claiming, and this is the fact dispute that will be resolved at the trial court. There are 4 licensed Kansas attorneys that practice full-time for Consumer Law Associates, and if the exemption applies to Consumer Law Associates, it's based on their conduct, and we have to show that the actions taken by Consumer Law Associates was within the course and scope of the conduct or their practice of law. And that's a fact question for the trial court, and that's why we're here today. We're not going to claim that a Maryland licensed attorney, Mr. Ruther, his conduct triggered this exemption, but we're claiming that the individual Kansas licensed attorneys are the ones who are supervising and engaged in the practice of law.
I guess it sounds very like a pretty complicated factual analysis that you would still have left even if you win, and I guess what concerns me is what does that say to consumers out there, like the plaintiffs here, about who they turn to know whether this practice is regulated? Do they have to file a lawsuit and duke it out like we're doing here and figure out, based on the facts, whether this qualifies as a person practicing law in the state or part of that person's law firm and acting within the scope? How does that help that consumer as they're, trying to figure out how this is regulated and how they can seek help, if that makes any sense?
Well, I mean,
if your fact-oriented analysis is the only way you can do that, it kind of puts them in a bad spot if they're dealing with an attorney who's not practicing in a typical law firm setting like this.
Well, and I suppose they'd have to just ferret out through their own counsel whether or not this qualifies, or they have a good faith belief that this qualifies as the practice of law or not.
Their own counsel. I mean, these people, your attorney was their counsel on their debt collection matters. They probably don't have counsel they want to go to talk about how to, whether your attorney was practicing within the bounds of the law, the protection law.
The alternative is to accept the Stork analysis, where all law firms would never be exempt, and I can't think of an alternative other than to do what the legislature did, which is to make it an exemption limited to attorneys practicing law. And what is the practice of law is a factual question according to this court's precedent.
And so you would say the consumer needs to make that analysis when they're in that debt collection process to know whether their attorney they're dealing with is regulated by the Kansas Supreme Court or
I think
consumer laws.
If they're represented by one of our attorneys, one of Consumer Law Associates attorneys, they're licensed Kansas attorneys practicing law, and I think that would be clear to them. I think what Your Honor is doing is considering all the factual arguments.
They were dealing with a person who you conceded is not he wasn't licensed in Kansas, he wasn't located in Kansas.
No, absolutely not.
Right. So how would they have known that somehow?
Each one of these consumers are assigned a specific Kansas licensed attorney who their only point of contact other than paralegals. And what I think this court may be doing is assuming some of the facts that are completely disputed and frankly baseless, in my opinion, that are being put out there. It's a straw man. It's a red herring saying, look at these contested facts. Well, we haven't gone through and explained all of the facts to you, but the point is, in this case, there was a licensed Kansas attorney representing each one of these defendants, or each one of these plaintiffs or consumers that are assigned to the case. Pick up the phone and call them at any time, correspondence from them. Now, I understand the facts are disputed, but before this court, I didn't want to get into, hey, let's have the court decide the facts. Instead, all the facts, according to statute, according to the certified question statute, must be set out in the court's order, Judge Martin's order, and they are all assumed. They are assumed that it's the actual practice of law by a licensed Kansas attorney acting within the course and scope of his practice, and that attorney is exempt. So that's the certified question. The rest of the facts are background information that are provided to this court. Now, in our case, there are licensed Kansas attorneys, with Kansas bar numbers, representing these individuals. Mr. Ruther was not representing these individuals. He is the owner and is sued because he's the owner of a corporation.
Okay.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
If it please the court, Dorinda J. Mitchell, Assistant Attorney General, representing the Kansas Attorney General Derek Schmidt, intervener in this cause. I am splitting my time with Mr. Peck, taking 13 minutes and reserving 7 minutes for Mr. Peck. If it please the court, questions certified to the court must be presented in proper context. KSA 603206 relating to certified questions requires that these proceedings follow the rules that govern other cases before this court. Rule 6.02 is one such rule. The rule requires that the facts must be keyed to the record before the court, and if the facts are not keyed in this manner, the court may presume that a factual statement made without such reference has no support in the record. Defendants' noncompliance with this rule allows them to portray what they do and who they are in an inaccurate manner. The defendants contend the reverse of Rule 6.02 is the practice, that they may, quote, presume a particular factual context without regard to the record.
How do you comply with that rule on a certified question where there isn't a record on appeal and all we have are just a statement from the federal court and some pleadings? I mean, it seems like you're really trying to push form over substance on this one, because we get these certified questions all the time and it's nothing more than just a legal question and here are the pleadings and now please help.
I understand there was a pretrial order that was found in this case, that was assigned in this case, and there were stipulations of fact in that which are contrary to the allegations before this court in this matter.
But we have that. I mean, I'm just trying to figure out, okay, fine, that's a rule when you've got a record on appeal, but what's it do to us? How are we supposed to use your objection here in order to answer the question from the federal court? That's the part I'm not connecting.
It's important that the defendants key their statements of fact to that pretrial order or to the actual contract that has already been stipulated to as a part of the proceedings in the federal court case. To allow the defendants to do otherwise allows them to camouflage their statements of fact with the erroneous presumption that Consumer Law Associates, or CLA, is a law firm.
Well, Counselor, clarify this for me. I understood this was a question from Judge Martin to the Kansas Supreme Court. Tell us what Kansas law is. Isn't that the posture of this case?
Yes, it is.
So why do we care about the defendant's brief or whether it's tied to facts? We have a legal question that we must answer for a federal district court judge. I think that's what Justice Biles is getting to. This isn't the normal scenario where we're applying the law to the facts. We're answering a legal question. And why isn't that presented to us? Assume that the attorney is acting within the course and scope of the attorney's practice, and now tell us whether that exemption insulates the law firm for which the attorney works.
The question assumes that CLA is a law firm, which it is not. The question also assumes that the practice of law existed in this case, which it has not been shown to exist. It assumes that there were licensed
So how do we
cannabis
handle
attorneys.
that? Do we tell Judge Martin, no, we're not going to answer your question because the facts don't support your question? I mean, this question came from the court. We send our answer back to the court.
I think the answer to the question is no, it is not exempt. CLA, if the question assumes that CLA is a law firm, it is not exempt from the protections provided to consumers in the state of Kansas. There's no Kansas licensed lawyer that's a named defendant in this case. There's no evidence that exists that a Kansas licensed lawyer directed the functions or actions of CLA. No evidence exists that CLA or anyone at CLA was supervised or authorized by a Kansas licensed attorney to conduct CLA's debt elimination services. The
But none of
defendants
those things are the questions before us. That's the problem. And I think we'd all grant you that we find certified questions to be very frustrating because often they do just seem like a hypothetical law school exam because we do ignore the facts. We just answer the question of law. And so the question of law is presented to us as if we do have an attorney licensed in Kansas who is practicing within the scope of their authority. And so that is the very limited question before us. Not whether or not that question fits the facts, because it may not.
If CLA is determined to be a law firm, which it is not, and it has not been shown to be that, it does not meet the definition of statute. So I think the answer to that first question is still no.
How
And
then
either
does an attorney
analysis.
practice law? If an attorney cannot use staff, if an attorney cannot use the trust account of the law firm, how does one practice law? I mean, how would this statute have any practical application as it's phrased to us?
Again, I think that the facts have to be clarified and projected. Otherwise, you're giving an advisory opinion and the overriding rule that hypotheticals and advisory opinions not be given by the court would be violated.
I think
the
certified
irony,
questions are an exception to that. I mean, we deal with it all the time.
it's our position that the certified question needs to be reviewed, analyzed in proper context, that it needs to be considered with facts that are before the court, and there are stipulations of fact that are before this court. The facts contrary to defendants' assertions. For example, CLA's electronic funds transfer authorization shows that the plaintiffs paid a one-time consultation fee of $199 on November 19th before even consulting a Kansas licensed lawyer. The first consultation with the Kansas licensed lawyer, according to the parties' stipulations in the pretrial order, did not occur until December 3rd. According to the contract, fees were assumed to be earned when paid, regardless of whether any services were actually provided. That's in page 11, or paragraph 11 of page 7 of the contract in Appendix B. In addition, CLA and the corporation known as EFA had what amounts to a fee-splitting agreement. The record before this court also shows that Kansas legal counsel were involved only in a limited number of instances. The defendants themselves refer to the attorney as an independent contractor. The word independent deserves emphasis. If the defendants had their way, every corporation that merely contracted with an attorney could be described as a law firm. Under the defendant's analysis, Walmart, Sears, or any fly-by-night retailer or service provider or supplier could call itself a law firm and escape compliance by association, merely associating with a lawyer, no matter how independent that attorney-corporate association might be. The consumer protection laws would be hollowed out and made meaningless under defendant's analysis of the law. Defendant's prophecy of doom is actually the reverse. Consumers of debt management services like that provided by the defendants could be exploited with impunity under defendant's theory of law. The harm to consumers described by the amicus bankruptcy trustee would persist unabated. The harms the consumer protection laws intend to avoid could persist.
If we agree with you, how do we respond?
I think we have to distinguish what law firm means.
No, my question is, we have a question propounded to us that says, if an attorney licensed to practice law in Kansas and acting within the course and scope of the attorney's practice is exempt from the provisions of the Kansas Credit Services Organization Act, is the attorney's law firm also exempt? That's the question before us. And if we agree with you that that doesn't really apply factually to this, do we just send it back to Judge Martin and say, I'm sorry, we're not going to answer this?
Well, I think that's the irony of defendant's separation of powers arguments. And their failure to key to the record is that defendant's defense amounts to nothing more than a request to this court to decide this case on a presumed hypothetical advisory set of facts.
The defendant's not asking us to do anything. A federal district court judge has asked us a legal question. And my question to you is, how do we respond to that judge? We're not talking to the defendant. We won't be issuing an answer to the defendant. We'll be issuing an answer to the federal judge. And how do we respond to that judge?
I don't think you can respond to the judge if the question requires you to assume that CLA is a law firm, or that it is practicing law, or that it has been supervised by those attorneys.
The problem, counsel, do any of the questions posed from the federal court ask us those questions? I mean, here'd be my notion. You got the question from the federal court, which is, if an attorney licensed to practice in Kansas and acting within the course and scope of the attorney's practice is exempt from the provisions of the Kansas Credit Services Organization, is the attorney's law firm also exempt? And we say, yes. Then all you do is go back to Judge Martin and say, that question, that answer doesn't have any application to consumer law because they ain't a law firm. I mean, we have a question in front of us, and so all we're trying to do is have help answering the question from the federal court. And I think trying to harp about the facts and whether the facts are keyed to the record is really just a ship passing in the night in relationship to what this question asks. I mean, for example, do you think that the statute is plain on its face and that the answer is required to be no to this? But the law firm doesn't get it because the law firm's not licensed to practice law. What's your position on that?
If you put it in those terms, I agree with you that the answer is a law firm is exempt if they're supervised and regulated and it's within the course and scope of that attorney's practice.
So you think we should answer the question yes, the law firm is exempt?
I don't think you should answer the question yes unless you qualify the answer that CLA is not a law firm. Also, I don't think you can answer that question if you are basing it upon hypothetical advisory sorts of questions. I don't believe
that none of that's a part of this. All we have is a question from the federal court that says, is a law firm exempt if the lawyer's exempt? And you're telling us that you believe the statute exempts the law firm. Not whether consumer law is a law firm or not. You can go fight that fight on another day and have all the fun you want.
Under the amended version of the law, it exempts a law firm.
No, we're not talking about the amended version.
Okay, no, it does not exempt a law firm under the prior version of the statute.
So your notion is that we should answer the question, no. The law
Correct.
firm is not exempt.
Correct.
Why?
Because the statute does not apply to people that are not, or entities, organizations that are not licensed to practice law.
From the plain language, just because it says.
Because of the plain language of the statute, yes.
And doesn't that plain language application basically make the statute a nullity? Because how does an attorney practice without the support of the law firm?
Well, again, it's difficult, and talk about confounding, it's difficult to explain it in this instance because that's not the example that's before the court. CLA is an LLC. It is not a law firm. It's an LLC. And the example before the court is clearly not exempt from the requirements and the regulation provided to consumers in Kansas.
Hey, counsel, I understood Justice Lickert's question to be more generic than that. How does any lawyer practice law without using the law firm's paralegals, assets, et cetera?
I don't think you can. I don't think you can practice law unless you're doing it all on your own. You're doing the work of everyone in the organization.
Let's take it a step further. I had a sole practice, so I would have been exempt, but my firm, as it were, which was a sole proprietorship, would have been liable, not exempt. Why isn't that a ridiculous result, as Mr. Joseph suggested, that I personally would have been exempt, but my bank account that was in the law office of Lee A. Johnson would not have been exempt? Sort of silly, isn't it?
Well, the law can sometimes be silly, but it is nonetheless the plain language of the law.
Let me put it another way. Would that be within the intent of the legislature?
I believe it was within the intent of the legislature as originally drafted. And there are all kinds of requirements, tax laws, lobbying, registration laws that apply to law firms or to lawyers, even though they're apart from the certified public accountancy laws, or they're apart from the requirements and the regulation of this tribunal under the professional rules of conduct. A lawyer, for example, is not excused from criminal conduct simply because the crime was committed during the course of the lawyer's practice of law. And all of this discussion does not mean that they are exempt from the Kansas Consumer Protection Act, because that provision is in addition to the rules that are found under the Kansas Credit Service Organization Act. And the Attorney General is free to separately pursue and prosecute cases under the Kansas Consumer Protection Act, apart from the Kansas Credit Services Organization Act. So a distinction needs to be made between what the lawyer would be exempt from if this court were to decide that a law firm should also be exempt. It's just an exemption that applies solely to the Kansas Credit Service Organization Act and not to the Kansas Consumer Protection Act as a whole.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
Mr. Justice, and may it please the court, my name is Martin Peck. I'm counsel for the plaintiffs, Marc and Jennifer Hayes. Listening to the argument, I'm going to go just straight off outline. How do we answer the question, I think, is what the court has asked several times. As much as my clients would be helped out by the answer that entities can't take the benefit of this exemption, 1116B, I don't know how you practice law without using a bank account, and so...
Well, what's the extension of that then? If you say we answer it yes, are you suggesting then that a paralegal is kind of a quasi-licensed attorney to practice law? Because that's what the statute requires, is licensed to practice law. Is the secretary or the administrative assistant sit in the same capacity?
What I've suggested, Your Honor, on page 9 of the plaintiff's brief is that there be a requirement of genuine supervision. But I hate to agree with the other side, but I think that the legislature's language was at least careless. They have used a defined term that includes entities that can't possibly have the attribute that term is supposed to have. I mean, there is no way for a non-natural person to be licensed to practice law in Kansas. Right. And so this court, I think, endeavors as best it can to always give effect to the language of a statute. But I believe this language is something like if the rule of statutory construction to which all others are subservient is that you're trying to define the role of the legislature. The legislature can't have meant that I can do something and my bank account gets sued. Because there's even if I do everything myself, I got to use a trust account. I got to put money in an account. I've got to have help doing the things I would do in order to do this. So I don't see any way to answer the first question in some way that's yes. You could qualify the yes. You could narrow the yes. I think the intervener has a recommendation for how to qualify the yes. This may not be a pretty rule of statutory construction, but to the extent that the court can adopt an analysis that is consistent both before and after the amendment, that way we don't have to have whatever else the defendants have to do. At least they can deal with Kansas law that's consistent, because at least that's the way that's
Why was there an amendment if this wasn't clear that it excluded anyone that was not licensed to practice law, and then they said no, we meant something different than that.
Until I read
why did they do that then?
Until I read the expert's opinion in the district court case in Stork, it never occurred to me that this exemption didn't apply to firms. It just struck me as so anomalous. But I recognize the conundrum. The plain language leads to, I think, at least strange and probably absurd results.
If we go to extra trouble to write in paralegals, using your notion of extra supervision, then don't we open the door to the mischief that the defendants might want to make in your case, which is to say a non-professional corporation, just a regular old corporation that happens to hire independent contractor lawyers gets the exemption too, because we're really, really watching those independent contractors, and they're really, really under our supervision.
Absolutely. You should read the opinion in KinderConnect.
And that's the problem, excuse me for interrupting, Counsel. That's the problem in not just marrying yourself to the legislature's language and just taking a plain language approach here and call it good. And if they don't like it, they can, and if you don't like it, everybody can go fix it. But it seems to me that, I can't even figure out all the mischief that can be done the second we try to include law firm secretaries and paralegals and maybe even independent contractors that are going to take some sort of action that then would clearly be intended to be covered by this statute.
And I obviously 4 judges have already come to that conclusion. They applied the statute as written. Not published, but 4 judges have already come to that conclusion.
But how does the paralegal do anything outside the scope of the attorney's license?
Well,
We license attorneys in Kansas, and we require that attorney to supervise staff. And so just because it's a AA or a research attorney or a paralegal, that doesn't divorce the attorney from the action of that person. I mean, how do you unhook those people from the licensure?
Well, and Your Honor, if I understand your question, I have a hard time doing that. I mean, you've seen the position I've taken in the plaintiff's brief. I have a really hard time arguing for the plain language result in this case, even though it helps my clients and there are 4 judges who've done it. With respect to the second question, at the risk of using the word hypothetical question, or the words hypothetical question, I'm going to use the words hypothetical question. I have a problem with the second question. The question of if the Kansas Consumer Protection Act applies to attorneys, does that violate the separation of powers? I don't think that's going to come up in the Hayes case. That may have come up in the Kinderconnect case, but I don't think it's going to come up in the Hayes case. And the number of ways in which, factually speaking, an attorney could be accused of violating the Kansas Consumer Protection Act that may or may not implicate the practice of law, I think makes that a very difficult question to answer. I would say that if you want to answer it, and I understand the motivation to want to answer Judge Martin's questions, as I say in the brief, I think the answer to that question is yes, the Consumer Protection Act applies to attorneys, generally. Now, there may be, you may start getting down to nice exceptions, but just like the court, determined in, I believe, Amani, surgeons are regulated, but that doesn't mean that they get a pass from the Consumer Protection Act. I'm out of time, but if the court has any questions, I'm happy to indulge them.
Do you think there's a solution such that I threw out to Mr. Joseph, that we just say that license was put in at the wrong point in the statute to do what the legislature wanted, and what they really wanted to say was any person acting within the scope and course of such person's person's practice as a licensed attorney in this state shall be exempt? Does that provide the protection for the consumer?
You have to do something. I mean, you'd like to do something. I suppose you can say, no, we're not going to answer the question, but that doesn't. So I think that is among the reasonable approaches that could be used to cut this knot.
The approach that the legislature took in revising the statute, to change the word person to individual and then add the and such individual's law firm language, we certainly couldn't do that, could we, within the plain language of the statute as it exists now?
It would be hard. Well, once you look at the definition of law firm, it gets difficult. And again, when I pled this case originally, I didn't rely on this particular interpretation of subsection B. That's going a little far, but that may be what they meant in the first place.
Well, and that's why can't we look at it that way? We have rules of construction to fit whatever we want to do. One being that they intended to change the statute when they amended it, changed the law. On the other hand, why didn't they intend to clarify? If there's cases out there that misconstrued what they intended, and they clarify it, why can't we get there through our construction rules that say ambiguities let us look at the intent and look at the history, and not only the history but the subsequent actions?
Were I on that side of the bench and not this one, I think that's exactly what I would do. I mean, that way you have a statute that the legislature's actually written that 3 years from now, another case comes back, or God forbid, this case comes back. We have, some language that the legislature wrote, and it can be consistent across cases.
And of course, it will come back because, as everyone seems to recognize, what we're going to be saying is whether someone is practicing within the scope of their, with a law firm, I guess, is going to be a fact question that the consumer isn't going to know the answer to. And that's what bothers me, is the bottom line is, even in the modified statute, it's still this fact question that the consumer that's sitting out there that has the problem doesn't necessarily know who the person they're dealing with is being regulated by.
I understand. I think that's a reasonable.
And I can't imagine the legislature intended that, either with the last statute or this statute, either way. But
As I read the statute, Your Honor, debt settlement for hire isn't legal whoever does it. But that's really not a question that's before the court. But were that interpretation to be followed, that would make, it may not be clear to consumers, but at least be pretty clear to anybody who read an opinion that debt settlement is not the practice of law, and you can't do that whether you're a lawyer or not, licensed or not. I mean, I don't think I can open Martin's debt settlement company. But that question has never been authoritatively resolved. And in terms of coming back, you have a sporting chance of not seeing this one again because it's going back to the district court. And so if we end up on appeal, we may happen in Denver instead of here. So you at least may be able to wash your hands of this particular case. But as all the briefs have said, these issues lurk in lots of cases.
Do we have any further questions of counsel? Thank you, counsel.
It concerns me a bit that we did not engage as much, I suppose, as appropriate in a factual dispute, because we do maintain that there are 4 Kansas licensed attorneys, the ones that were talking to the consumers, are the people who are regulated by the Kansas Supreme Court, who are the ones whose practice is being evaluated. It just happens to be in this case the defendant is a law firm or an entity, much like Stinson, Morrison, Hecker, organized in another state. All of our questions are premised on the practice of law of these 4 individual licensed Kansas attorneys. Judge Martin, and I think you all hit it directly on point, has set the facts, and it's not a hypothetical. In fact, Judge Martin, and I want to reference page 3 of his order, the proposed questions are not hypothetical, but are firmly grounded in the factual contentions and legal issues raised in the pretrial order, and the resolution will materially affect the outcome. He writes that because we are maintaining that actions taken were within the scope and course of the practice of licensed Kansas attorneys. The factual disputes will be ferreted out below. I understand they disagree. The opposing parties disagree. But that is why the presentation was made of those facts to this court.
And one of the things we look at is whether the answer to the question will dispose of the case or be dispositive. And actually, that would be the situation here, correct? That if
no law firm can ever be exempt, we lose. And I think that would be terrible policy to say no law firm could ever be exempt, because that very much directly impacts individual practitioners in Kansas and their law firms. It impacts me. It impacts, and the best example that comes to mind, personal injury attorneys. You get in a settlement amount, and the first thing you do is deal with the liens and the medical bills that are owed to consumer debt before you distribute the money. They would trigger the KCOSA. Their law firms would be impacted and subject to regulation and subject to penalties for their practice of law. It would impact Kansas lawyers to answer the question that they could never be exempt, and it's very important in that respect.
How do we deal with the presumption that when the legislature amends a statute that it intends to change the law?
The presumption's overcome by the language in legislative history in this case. It very clearly says, hey, that's not what we meant in 2004. We're clarifying this. I understand that presumption exists, but it's clearly rebutted in this case. It is a clarifying amendment in response to the language in the historic opinion, whether or not that's dicta or not. It's a direct response to that historic opinion. Now, I also want to address Justice Biles' concern about mischief. If there is mischief out there, the solution has to be to look at the individual facts of the case. You lose not on the law to say no law firm can ever be exempt. If there's mischief, It must be resolved on the facts of the case at the trial court level. The result would otherwise be throw the baby out with the bathwater and make all law firms, even real legitimate law firms, unquestionably legitimate law firms like Folston and Siefken, like Stinson, Morrison, and Hecker, always liable. If there's mischief, it must be addressed with the facts of the case, much like a malpractice situation or any other case where consumers left wondering, do I have a cause of action?
Well, do you agree that Consumer Law Associates doesn't benefit from an answer to this question because the 4 lawyers that you're talking about, the Kansas lawyers, this Consumer Law Associates is not their law firm?
No, absolutely. It is their law firm. There's no question it's their law firm. Now, I understand they say to the contrary. I understand that Judge Nugent looked at a contract and concluded that they're independent contractors because it said so. But there's no question that they are agents of Consumer Law Associates. They practice full-time. The amici got it right. The issue is of agency and respondeat superior. It is their law firm. Those are fact questions that we will resolve, and I anticipate quite favorably on our behalf. It is their law firm. It is a traditional law firm, other than it's set up in a way where they are not all in the same brick and mortar structure. It is their law firm. Okay. Now, I understand that there are issues out there that suggest, or there are decisions out there, or there's positions taken by other folks that say it's not the case. But the district court believes that that's our position, it is, and says it is not a hypothetical question, that this will resolve many of the questions before, pending before it in that matter. So, I believe that the answer to the first certified question is yes, that 3 out of the 4 parties agree, and in fact, I think now 4 out of the 4 parties agree that law firms can be exempt depending on what happened, whether or not it was taken within the course, done within the course and scope of an attorney's, licensed Kansas attorney's practice of law. That is the situation as we maintain it. The parties below maintain we never even look at those facts because you just lose. That's why you have the certified question. They say, Stork, you lose. So we need to get to the facts, and we need to get the facts in the district court, and the answer by this court will allow that to happen.
Any further questions of counsel? Thank you, counsel. Thank all of you for your arguments this morning. The court will take this matter under advisement.